Can you empty a house before probate? What to do with personal belongings after death without a will or with a will? That's our topic. Losing a loved one is an emotionally challenging time that often leads us with a sea of questions. One of the main concerns involved around what happens to all the personal belongings after death left in a decedent's home, especially when it's not explicitly mentioned in a will. This question is particularly common in San Diego, where estate laws and the probate process can be long and it can be complex. Often family members wonder if it's okay to start removing items before probate from the decedent's home without asking anyone. The simple answer, absolutely not. Unless the executor or the administrator of the estate gives explicit approval, and they should only do that when the item is clearly gifted to someone or to an entity in the will. Other than that situation, no one should be taking anything from the home. Hi, I'm KimWard. Welcome back to my channel. I am a certified probate real estate advisor, and I am the broker of Horizon Real Estate's Probate and Trust Help. My team and I have been helping with homes in probate or trust administration for 2 decades. Now, let's start by talking about the role of an executor. When someone passes away and they leave a will, an executor is included in the will to handle the estate. This person has the challenging task of settling everything according to what is written in the will. This includes figuring out the value of personal items like furniture, cars, what's in the bank accounts, where are the stock holdings, and other possessions. They also need to account for any real estate properties like land, commercial buildings, and of course, homes. The executor, well, they can't just sit back and let people take whatever they want from the home. For example, if a will specifically leaves a big screen TV to someone, it's the executor's job to ensure that person gets it. On the other hand, if no one was specifically left the TV in the will, it should be added to the general inventory of the estate. Then the executor can decide whether to sell it and distribute the cash according to the will or give it directly to a beneficiary. Here's a quick example of how messy things can be when someone puts something in a will, they pass away, and then the person that is responsible to manage the estate, including whatever was left in the will. This is an example of where it can go wrong. Just recently, we were helping with a home in San Diego, and there was a very old, at least 20 years old, but not old enough to be great, car sitting in the driveway. It was not operational and pretty rusty. I'm not even sure the doors opened. I never tried it. But our client had the responsibility, since it was in the decedent's will, to get the car or offer the car to the nephew. And guess where the nephew lived? Chicago. I guess Chicago's that way. Chicago. Anyway, it turned into kind of a responsibility that was difficult for our client because the car wasn't running. The nephew wasn't in any big hurry to come get the car, and the nephew had a friend that was an attorney that said our client couldn't touch the car. Long story, a few weeks later, permission was given to be able to touch the car, so our client had to get a tow truck to load up this really old rusty bucket car and take it to a secure location, and that's where it is right now. I don't know what's going to happen with it, but you can see how that is a huge financial drain on the estate because the decedent inadvertently put this car in his will. Moving on, let's share about the importance of preserving personal belongings after death. Preserving everything in the estate until it can be distributed according to the will is crucial. Sometimes executors, administrators, and trustees even secure homes to ensure everything inside stays put. Securing the property is an essential step in removing items before probate, and we always recommend that the locks be rekeyed or changed so that the items in the home are not removed by someone that has the keys to the home. Just because a will doesn't mention every single item doesn't mean family members or friends can start helping themselves to the personal belongings and removing those items before the probate occurs. If someone takes something without the permission of the estate and the estate representative, they could be in hot water legally. Every situation is different, but it's possible they could be charged with burglary or theft if someone involved with the estate chooses to go that route. So when someone dies, their personal belongings after death don't just become up for grabs. It belongs to their estate, their entire estate, until it is properly distributed. So taking something without the personal representative's permission could get you into some serious trouble, and we don't want that. And of course, there are legal consequences of premature removal of personal belongings after death. There have been times when misunderstandings have caused problems. For instance, a family member might assume that because they were close to the deceased, that they have the inherent right to certain items. However, this is not how the estate laws work. Again, if someone removes property without permission, it could be potentially illegal. Ownership doesn't fall into a void upon death. The property belongings after death technically belonged to the decedent's estate until it is distributed. Therefore, taking property that wasn't bequeathed or distributed by the executor, administrator, or the trustee could potentially constitute a crime. Now let's get into the even more complicated personal belongings after death without a will, and what can happen if there is no will. It's important that you know that this is a common scenario and can complicate matters. When someone dies without a will, it's called dying intestate. In such cases, state laws dictate how the deceased's property is distributed. Typically, the property is divided among the closest living relatives, such as the spouse, the children, or the parents. However, just like with a will, until the estate is officially settled or permission is officially granted, no one should remove personal belongings from the deceased's home. In the case that there isn't a will, an administrator, which is often a family member, a close relative, or a friend, is appointed by the court to handle the estate, similar to an executor. They have the responsibility to distribute the assets fairly and according to the state laws. While it may be tempting to start clearing out your loved one's house after their passing, it's important to respect the legal process. Whether there's a will or not, removing items before probate without permission can lead to potential legal trouble. It's always best to wait for the executor or the administrator's guidance to ensure a fair and legal distribution of the deceased's personal belongings after death. Deaths, well, they can be overwhelming, and dealing with personal belongings after death can be a complex process. But understanding these key points can help you navigate this challenging time with greater ease and clarity. Please note that while this guide offers a general overview, it's always best to consult with a legal professional in your area to understand the specifics of your situation. Laws can vary greatly by location and individual circumstances. So, thanks for watching. Hit that bell button, all the things. Tell the algorithm that you find this helpful so that it'll show it to other people. Thanks, and I'll see you next week.